Judge, I didn't know you left. Number 13's wife is outside of the courtroom. She's sitting out on the bench, just so you know. But she
Oh,
said she wasn't a victim or nothing, Jack. She's sitting out there. But I told her to be on video so she can just watch it.
We should have outside the court.
Huh?
Thank you, Mr. Howard.
right.
After you, Ms. Bridgewater, can you give us the reset dates?
yes, and I also have a correction that we're gonna correct on this end, but it's going to be December the 6th.
And what was, or do you need to make an announcement regarding that?
I will. Oh, you can, Your Honor.
What? What's the,
Yesterday, I told them the 13th, but it is in fact December the 6th.
great. Can you hear me, Ms. Bridgewater?
I can.
Okay, so the SAP reset date for yesterday and today is December 6th?
That is correct, Your Honor.
Okay, thank you. Where are we beginning this afternoon?
Good afternoon, Judge Morrow. We're going to be starting with position 1, Ms. Bickle.
Okay, good afternoon, Ms. Bickle. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, I do, Your Honor.
Thank you. You have been charged in case 22 CR 007911H with driving under the influence of multiple substances, possession of an open alcohol container, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
The third arrest, 2017 DUI. It was amended to a non-fingerprintable offense. It was a conviction, whatever they amended it to. 2021 DUI conviction out of Roswell. That's it.
Afternoon, Ms. Backus.
Good afternoon, Your Honor. In addition to what Mr. Howard said, the 2017, as I compare it to the driving history, it looks like it was reduced to reckless driving, and that was a suspension. And then they have some other driving. It looks like there was in April of 2020, it looks like there was a DUI, even though that's not on the GCIC, it is on the driver history. And then anything past that is fairly remote. This incident occurred yesterday. The defendant was driving their vehicle down Village Green Drive. A traffic stop was conducted. The officer observed and believed that the defendant was under the influence due to the odor of alcohol coming from the defendant's breath, as well as the defendant having watery eyes, slow and slurred speech. At some point in the encounter, it was told to the officer, or either the officer heard it, the report is not fully clear, but it did say that the defendant admitted to a third party that she had taken Xanax earlier in the day. The officer then asked the defendant to participate in the field sobriety test, to which the defendant agreed. The test showed numerous clues of impairment. The officer did search the vehicle and located multiple open containers, as well as a bottle of prescription Xanax. The defendant did admit to the officer that she had taken the Xanax earlier in the day. And inside the car, there were also 2 open bottles of whiskey and a Coke bottle that smelled like an alcoholic beverage. When the officer attempted to take the defendant in custody, he was passively resisting, at one point even collapsed to the ground to prevent movement. Your Honor, based on the history and the previous DUIs, the state is requesting a $4,000 surety bond, no alcohol, drugs, or weapons while out on bond, and no driving if there's an active suspension. Which I believe that there would be, because it looks like on the driver history from September of this year, there's a refused implied consent. And so I would assume that there would be a suspension. Let me check while PD Gann is speaking.
Would you break down your recommendation for me, please?
Yes, Your Honor. The $3,000 surety bond for the DUI and $500 for the remaining 2 counts.
Thank you. Mr. Gant, good afternoon.
Good afternoon, Your Honor. Ms. Michelle Bickle is 52 years old. She has been in Atlanta, the Atlanta, Georgia metro area since 1993. She is a proud mother of 4 children, ages 11, 12, 19, and 20. She is married and has been since 2018. She completed high school and has a bachelor's in business administration. She is currently employed, although for just a brief period of time. She started a new job last Monday, therefore she is still on probation and is missing work. She is employed at a physical therapy clinic as a patient coordinator. She strongly denies the allegations and she is presumed innocent. I am requesting a signature bond on Ms. Bickle's behalf. If Your Honor determines that she is ineligible, then I would ask for a more reasonable bond, no more than $1,000 for the DUI and $250 for the remaining charges, for a total of $1,500. And we are, of course, opposed to any restrictions on her driving, and unless and until such privileges have been suspended in an administrative law hearing, Your Honor. Thank you.
Was there anything further, Ms. Backus?
I'm sorry, Your Honor. As you know, Odyssey is running slow. I'm just trying to look and see if there is an active suspension. There is an active suspension, it looks like. I don't see the reinstate date, so I'm not sure, Your Honor. But we would, the state would request that, and that's fine what PD Gann is saying. The state would request that if the driver privileges are suspended, obviously there should be no driving. Yes, and no alcohol, drugs, or weapons.
Okay, thank you. For the DUI, it's going to be a $1,500 good bond. For the possession of an open alcohol container, $500 good bond. Willful obstruction, $500 good bond, makes it a total of a $2,500 good bond. No drugs, alcohol, weapons while out on bond, and if there is an active suspension, she must abide by it. All right, good luck to you, Ms. Bickle.
Not an active suspension.
Thank you, Your Honor.
Not an active suspension.
Ms. Bickle, if you have any questions or concerns about your bond, I'm happy to give you a call. Otherwise, I don't want you to make any statements about your case.
Yeah, if it were suspended, you would have said something when he pulled me over. It's not suspended.
I will give you a call, Ms. Bickle.
Position 18, Wagner.
Good afternoon, Ms. Wagner. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 007914E with battery, family violence, and cruelty to children in the third. Is there a history, Mr. Howard?
It's a 4th arrest. Last was 2021 disorderly conduct out of East Point. It was amended to a non-fingerprintable charge. She got first offender for shoplifting in 2013. And terroristic threats, there was dead docket from 2012. That's it.
Good afternoon, Ms. Campbell.
Good afternoon, Your Honor. As to this defendant, the facts as alleged are that on the date of November 19th, 2022, at the location of 2958 Blunt Street in East Point, this defendant punched her live-in girlfriend, and her name is Vonceille Griffin, and that's spelled VONCILLE. The defendant punched her girlfriend in the face multiple times, and the victim's 10-year-old son actually was the one to call the police. He heard his mother getting beat, and he heard the defendant yelling profanities at his mother. So he did call 911, and he did tell the operator that he wanted to make the call anonymously because he was afraid that he would get in trouble for calling 911. The officers did arrive, and they did observe swelling and redness to the victim's face, and they also observed an injury to her lip. As pretrial mentioned, her last arrest was for disorderly conduct in Cobb County. I don't have that she has any violent convictions on her record. However, the state does believe that this defendant poses a danger to the victim in light of the facts of this case. More specifically, the fact that the victim's child was present in the home at the time, but for the child calling the police, arguably the defendant would have continued to beat the victim in this matter. So not only did the defendant cause harm to the victim, the adult victim, but the defendant caused harm to a minor child that was 10 years old. So the state is asking for a $4,000 surety bond for those reasons. The breakdown of the state's bond request is $2,000 on the family violence battery and $2,000 on the cruelty to children. The state also recommends anger awareness, as well as no further contact with either victim. Von Seal Griffin, the other victim would be the minor child. And the state is also asking for a stay away.
Has your office spoken with Ms. Griffin?
I do believe we've had contact with the victim in this matter. She did indicate that she doesn't even know how the police got called. And she indicates that she doesn't want to press charges.
Okay. Ms. Kim?
Yes, Your Honor. My client, Ms. Wagner, she is 30 years old and they no longer have any relationships. They do not live together anymore. Apparently they don't have any children either. So my client has no objection to stay away nor further contact. She is actually residing with her sister in Lithonia, which is far from East Point, and there will be no further contact whatsoever. My client has been working at a new job for the last 2 weeks to deliver the parts to 18-wheelers, and she does not want to lose her job. She wants to go back to the job, which is relatively new, and she graduated from high school and she pleads not guilty. She is strong about that. She has contrary evidence that she can prove that she's not guilty, and we would like to request for a signature on bond for this particular case so she can go home and spend time with his family at the for the Thanksgiving. Thank you.
All right. So for the cruelty to children, it's $1,000 signature bond through pretrial. For the battery, a $2,000 signature bond through pretrial. So it makes a total of makes for a total of a $3,000 signature bond through pretrial. 1-day anger awareness, no further contact with Ms. Griffin, stay away from the Blunt Street address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Wagner.
Thank you.
Position 14, Miller.
Good afternoon, Ms. Miller. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, good afternoon.
Good afternoon. You have been charged in case 22 CR 007912A with simple battery family violence. I'm told by pretrial that this is Ms. Miller's first arrest. Ms. Campbell?
She's 17, so she'll need a cosign.
Thank you.
That is correct, Your Honor. The state does also have that this is her first arrest. The facts as alleged are that this defendant and her mother, the victim, Ashley Miller, were driving within the vicinity of 10 Park Plaza, which is in Alpharetta. It's the Alpharetta City Library. At that time, they were discussing their uncle's estate, and somehow an argument erupted. The defendant did strike her mother in the face, and her mother did call the police. Upon arrival, the officers did not observe any injury. However, the defendant did admit to striking her mother in the face because her mother called her names. So for the reasons that this defendant is 17 years old and has no prior arrest or convictions, the state would consent to a $3,000 signature bond through pretrial services. The state is also recommending no violent contact with the victim, Ashley Miller, as well as 1-day anger awareness, as well as a 9 p.m. to 6 a.m. curfew. Nothing further.
Good afternoon, Mr. Lynch. Is this your case?
Yes, Your Honor.
Okay.
So we would ask that you accept that recommendation as far as release. Now, I know that she does work, excuse me, but I'm not sure if that would interfere with the curfew, but I would ask that if it's for work, I'm trying to see where I have her working. I guess she's in high school. She's a senior at Alpharetta High School. She does work at a restaurant. That's right. I can't remember the name of the restaurant, but we would just ask that she be allowed to work if that does go through the curfew. As far as her being 17 years old, her mother, who is the alleged victim in this case, is going to be the only adult contact that she has. I'm not sure if we can sound for her. I did try to make contact with her, but I haven't made contact. Can we see if she's on the call by any chance?
She's here in the gallery.
Okay. I don't know if we maybe ask whether she would be willing to sign for her to be released.
Tell the judge I'm bringing her in.
Yes. Yes.
Come on.
Good afternoon.
Good afternoon, Ms. Miller. I'm Judge Eric Morrow. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, ma'am. Your daughter is going to need a cosigner if she is to be released. Are you willing to be that cosigner, and you willing to have her back into your household?
Yes, as long as she is compliant with whatever, rules and regulations, I'm fine with that.
Okay, are there some rules and regulations that she's not abiding with that you're having issues with?
Just mainly being respectful. I think she has a very resourceful and a life of somewhat privilege, and it's an issue of entitlement at times. And I just want her to be respectful. I'm a single mom and I work very hard, and I just feel that that needs to be valued. She's 17, she's a bright girl. She's very smart, and it's time that she take advantage in the right ways.
Is she properly attending school?
Yes.
And do you believe that a curfew would be helpful for her at this time?
Yes, however, she does work, and sometimes her work does require that she gets off at around 10:30 to 11 o'clock at times. So that curfew may not work for her as far as her work schedule. She is a very good worker.
Is she normally home by 11 o'clock?
Yes, I pick her up. We don't have any family here. I'm literally her only means of transportation aside from Uber.
So if I impose a 6 a.m. to 11 p.m. curfew, so that she can leave for school, but she can't be out past 11 p.m., would that be helpful for you?
Yes.
Okay, so we'll do that. Anything else, Ms. Miller, that you want the court to know?
No.
Okay.
You gonna waive the utility bill, Judge? Since she's
Oh.
in court, I'm sure she don't have one.
Yeah, since she's in court, I'll waive the utility bill so that she doesn't have to go and find one. So so you'll have to sign for Ms. Miller. It's going to be a $3,000 signature bond through pretrial. She's to have 1 day of anger awareness, no further violent contact with her mother, Ms. Miller, and no drugs, alcohol, or weapons while out on bond. I'm also going to impose that curfew, 6 a.m. to 11 p.m.
11 p.m. to 6 a.m.
Yeah.
11 p.m. to 6 a.m. Yes.
What's mother's name?
Ashley Miller.
Ashley Miller.
You have any other questions, Mr. Howard?
No. I'll call the pretrial intake. Francois, can y'all send mother to the intake, please?
Yeah.
So she can co-sign. All right. That's it, Judge.
Thank you. Good luck to you, Ms. Miller, both of you all.
Thank you.
Position 9, Henry.
Good afternoon, Mr. Henrys. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 007920D with driving under the influence of alcohol less safe, willful obstruction of law enforcement officers, improper erratic lane change, and distracted driving. Is there a history, Mr. Howard?
I was on the phone. Who is this, Judge?
Position number 9, Mr. Henrys.
Henry's. It's his 5th arrest. Last arrest was 2016, theft by taking. On probation and card for theft by taking. In 2017, they gave him 10 years probation. 2014, suspended license arrest, driving without a valid license. The driving was a conviction. Got a 2015 DUI, driving without a valid license. DUI was a conviction. 2014, he had a DUI that was amended to reckless driving. That was a conviction. That's it.
Your Honor,
Yes.
this incident occurred yesterday. An officer was dispatched to the area of Highway 92 in reference to an erratic driver. An off-duty officer called dispatch and said that he was behind a car that was failing to maintain lane, and it looked like the driver was on their cell phone. When the officer located the car, conducted a traffic stop, as soon as the defendant rolled his window down, the officer smelled a strong odor of alcohol coming from his breath, his person. He also had bloodshot and watery eyes. So the officer asked him if he had had anything to drink prior to operating the vehicle, and he stated that he had not. He stated he was on the way back to his girlfriend's house, but didn't give an address to the officer. And the officer asked the defendant again multiple times if he would participate in the standard field sobriety test. To determine if he was safe enough to drive the vehicle. The defendant then he refused. And one second, Your Honor, make sure that I have this correct. At that time, Your Honor, basically the officer placed the defendant into custody. Based on the open probation, the 2015 DUI conviction and the 2014 that was amended to the reckless driving, the state is going to be requesting a $7,500 surety bond, $6,000 on the DUI and $500 on each remaining count, no driving and no alcohol, drugs, or weapons while out on bond. Nothing further.
Thank you. Ms. Gant?
Thank you, Your Honor. Mr. George Henrys is 31 years old. He has been in the Atlanta, Georgia area for 10 years. He has family here, including his sister and his mother. Mr. Henrys completed high school. He also has a bachelor's in political science. He is currently employed at Yamaha Motor Corporation. He has been in that position for 2 months. However, prior to that, he had been unemployed for a period of time. Therefore, he does have very limited resources. He strongly denies the allegations. He is presumed innocent. I am requesting a signature bond on Mr. Henry's behalf. And if Your Honor determines that he is ineligible, then I would ask for a more reasonable bond, no more than $2,000. That would be $1,000 for the DUI and $500 for each of the remaining counts. And we are opposed to any restrictions on his driving privileges. We would ask that he allow the process to play out to have his hearing before an administrative law judge, Your Honor. Thank you.
Your client has his hand up, Ms. Gant.
Mr. Henrys, unless this is a question about, well, actually, I would advise you not to make any statements at this time. I will certainly give you a call regarding this case at the jail. I don't want you to make any statements.
I'm not on probation anymore. That's all I'm saying.
I don't want you to make any statements at this time, Mr. Henrys.
All right, so for the DUI, it's going to be a $1,500 good bond, willful obstruction, a $500 good bond, erratic lane change, $500 good bond, distracted driving, $500 good bond, makes it a total of a $3,000 good bond, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Henrys.
Thank you, Your Honor.
Position 10, Hill.
Your Honor,
Yes.
I do apologize for interrupting. Ms. Bacchus, may you please check your chat for a message from me, please?
Yes, let me see.
Thank you.
Mhm.
Doesn't involve this case.
Okay, thank you. Mr. Hill, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 22 CR 007921A with battery, family violence, and cruelty to children in the third degree. Is there a history, Mr. Howard?
11 total. Last arrest was back in September. Cobb County, failure to appear. It was for a felony. Also arrested in September for suspended license, suspended registration. I didn't see any violence in this history. 2017 burglary in the second degree, possession of marijuana. Not sure what happened with that. Before that was the 06 shoplifting. Just came off of a 05 no-low. That's it.
Yes.
Yes, Your Honor. This incident occurred back on August 30th of this year. A third party contacted the police because she witnessed the victim, Miss Alicia Kelly. Alicia is spelled Elishea. Last name is Kelley. She witnessed Miss Kelly being attacked by the defendant. Officers responded to 1280 Hartford Avenue Southwest and spoke with Miss Kelly, and she said that she found out that her child's father had come by her house, picked up their daughter, Kimbrella Hill, who had been at the home with her 19 and 17-year-old brothers while Miss Kelly was at work. So she then went to where she knows the defendant hangs out. When she got there, she called to her daughter who was on the porch and told her daughter to come to her, which she did. But then she told the defendant that he could not just come randomly get the child, but he needed to call first. She said that's when he attacked her. And at some point, the assault left the vehicle and moved to the street. She noticed that I guess the third party saw Mr. Hill shouting at Miss Kelly. And that's when Miss Kelly shouted out, "Someone please call the police." And the third party called. She advised that she saw the defendant screaming and kicking Miss Kelly when she was inside the vehicle. And as soon as the defendant found out that she was calling the police, that's when he fled the scene. Your Honor, the state is going to be requesting a $3,500 surety bond, $3,000 on the battery family violence. I'm sorry, $2,500 on the battery family violence, $1,000 on the cruelty in the third. A no further contact with Alicia Kelly, a third party transfer of the child, and stay away from that incident location of 1280 Hartford Avenue Southwest. No alcohol, drugs, or weapons while out on bond.
Ms. Kim?
Yes, Your Honor, Mr. Hill. He is 38 years old and he is Georgia native. He has only one child with Miss Alicia Kelly, who is a mother of child. Your Honor, they do not reside together and they only have one child together who is 3 years old. And my client is completely okay with stay away from 1268 Hartford and no further contact with Alicia Kelly as long as he has a third party visitation right for his child. He was indeed detained at Cobb County. He was arrested and he was incarcerated in Cobb County for 75 days. He was transferred to Fulton County yesterday. So those FTA, those previous cases were taken care of by him serving at Cobb County. He would like to go home for his Thanksgiving. He's been missing his home a lot, and it has been already almost 3 months that he was out of the society. This incident happened on August 30, 2022, very remote. However, my client is still willing to have no further contact with Miss Kelly at all. And we would like to request for signature on bond since he already served a lot of times at the jail. And I think that this is the only first serious violence case that he has ever been involved. He has no job, of course. He had a job, but he lost it because of his incarceration. His highest level of education is 11th grade, Your Honor. Thank you.
All right, so it's going to be for the battery, a $4,000 signature bond. For the cruelty to children, $1,000 signature bond. I'm going to send this through pretrial per the judge. So it's a $5,000 signature bond through pretrial per the judge, 1-day anger awareness. No further contact with Ms. Kelly. Stay away from the Hartford Avenue address. He can have third-party transfer of the minor child for visitation. No drugs, alcohol, or weapons while out on bond.
Thanks,
So
Your Honor.
I'm going to let you out, Mr. Hill, on a signature bond, but you're going to have to make sure that you come back to court for your next scheduled hearing. Okay?
All right, thank you, Your Honor.
Was that 5,000 in total, Your Honor?
Yes, 4 and 1.
Thank you.
That's the pretrial, correct?
Yes, that's through pretrial.
Thank you. Position 12, Mathis.
Good afternoon, Mr. Mathis. I'm Judge Eric Morrow. This is a state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Say it again. Is that a yes?
Say it again, yes, sir.
Okay, thank you. You have been charged in case 22 CR 007905C with criminal trespass. Is there a history, Mr. Howard?
Fourth arrest. Last was 2011 probation. Underlying charge was armed robbery, felony theft by taking. 2010 identity fraud that was dismissed. She got first offender for the theft by taking in 2010 out of the cab. Armed robbery was not a That's it.
Ms. Campbell?
Yes, Your Honor. The facts as alleged for this defendant are that on the date of June 21st, 2022, at the location of 50 Mount Zion Road, this defendant went to the victim's home. The victim's name is Letitia Rhine, and that is spelled Lateshia. Her last name is spelled Rhyne. She went to Miss Rhine's home, and basically Miss Rhine, the victim, was in a relationship at the time with the father of the defendant's child. And so she went to the home because she had had a conversation with the victim about dropping the children off, and the defendant did not get the answer that she desired to get. As a result, she went to the home and she began issuing threats towards the victim in this matter. The entire incident was captured on Ring doorbell. And so when the officers reviewed the Ring doorbell footage, they did observe the defendant yelling profanities at the victim and kicking the door of the victim's home. They also observed damage to the front window of the victim's home when they arrived on scene as a result of the defendant's actions. So the state does recommend a $3,000 signature bond through pretrial services, a stay away from the victim, Letitia Rhine, no contact with the victim, Letitia Rhine, a stay away from her address at 50 Mount Zion Road, as well as 1-day anger awareness. As pretrial mentioned, the last conviction was in 2010. It was a first offender. So the state is fine with the $3,000 signature bond.
Ms. Kim?
We have no objection, Your Honor. However, this happened on June 2021. So we would like to request for a signature on bond through jail. Other than that, we have no objection, Your Honor. Thanks.
Ms. Rhines, I see you there. This is your opportunity to speak. If you would like to speak, you're not obligated to speak, but if you would like to address the court, I'll need for you to raise your right hand and I'll have to swear you in. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. Thank you. What would you like to tell the court?
I feel she's not gonna come to court because we just had court November 7th for her to pay me. We had mediation arrangement and she failed to provide my money for coming to court. As of she didn't come to court November the 7th. So I don't think she's gonna come to court if
Your
she
Honor,
said I don't
objection. Totally
at all.
irrelevant.
Speak, Ms. Campbell. I overrule the objection. Anything further, Ms. Rhines?
No.
All right, so it's gonna be $3,000 signature bond through the jail. No further contact with Ms. Rhines. Stay away from the Mount Zion Road address, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you both.
Thank you.
You're welcome.
Position 3, Clark. I'm sorry. It's gonna be Lawrence Clark.
Judge Morrow. How you doing there?
Doing fine, Mr. Clark.
Happy Thanksgiving to you, sir.
Happy Thanksgiving to you too, Mr. Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're doing by video. Do you agree to have your case heard by video? Right. Mr. Clark, you have been charged in case 22 CR 007879Y with willful obstruction of a law enforcement officer, theft by shoplifting, and criminal trespass. Is there a history, Mr. Howard?
Yeah, I think 38 total. He went to felony earlier. I think he got a $15,000 good bond. 2018 simple battery, no low out of Gwinnett. 2019 obstruction conviction. 2019 obstruction conviction. Got a theft as well. Last arrest was in July for simple battery. That's open. 22 CP 211093. Got an open criminal trespass damage, given false name. That's 22 CR 003264Y. Got history out of Illinois, Indiana, and Nevada. 2019 failure to appear.
Those criminal trespasses and damage to property, is that pending in Fulton?
Yes. Hold on. This thing all over the place. Yes. That's in state court. And then he got the open felony, simple battery against police, and obstructions and drug-related objects. That's the 22 CP, which comes from July. He went to felony. He had a burglary in the second degree, felony obstruction, and an FTA. So that's it.
Raise your hand first.
Okay, hold on, Mr. Clark. Mr. Clark, you have a right to remain silent. Anything you say can be used against you. I'll give you the opportunity to talk with Ms. Gann if you need to, but hold on for us, okay?
Yeah.
All right, thank you.
I would
Thank
like
you.
to elect.
Mr.
Hold on.
Clark, please remain silent.
I don't want you to say anything that's gonna hurt your case.
I'm not new to this, sir. I know. I'll wait.
Okay, all right. Well, thank you. I appreciate it.
My
Ms. Campbell,
apologies, Your Honor.
you're fine, Ms. Gann. Thank you. Ms. Campbell.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of July the 10th of this year, at the location of 842 Peachtree Street Northeast, which is a CVS, this defendant took a case of beer. He was captured on surveillance video doing so. When the officer arrived to do investigation, the defendant fled from that officer and threw down items to assist in his escape from the officer. And so this defendant was charged with 1 count of obstruction for fleeing from the officer, 1 count of theft by shoplifting, as 1 count of criminal trespass, because it's my understanding that he had been previously, I believe he was previously banned from the CVS. And so as pretrial mentioned, there are several prior convictions and arrests for trespass, as well as obstruction. He's a multi-state offender. Some of the Illinois arrests consist of trespass, as well as resisting arrest, as well as battery against a police officer. Some of the Nevada arrests, as recent as 2017, consist of resisting arrest, as well as obstruction. We have the same thing in Indiana. He has a 2015 conviction for resisting arrest. And so he essentially does the same thing in every state that he's in. He obstructs law enforcement, sometimes, acts in a violent way towards law enforcement. And he just consistently evades arrest, and he's non-compliant towards law enforcement. So the state's position is that a surety bond is the appropriate type of bond for this defendant. And so for that reason, the state's recommendation is a $1,500 surety bond, $500 surety bond on each of the 3 counts. The state also recommends a stay away from 842 Peachtree Street, which is the CVS. Nothing further.
Ms. Gant?
Thank you, Your Honor. Mr. Lawrence Clark is 33 years old. He has been in the Atlanta, Georgia area for 6 years. He is the proud father of 4 children, ages 4 and 9 months. He completed high school. He served in the Marine Corps for 5 years, and he went on to earn an associate's degree in sociology. He was employed at Hector's Catering Service. Your Honor, he had been in that position for about 2 years. However, due to the length of time that he has been incarcerated, it is likely that he has lost his job. Therefore, he does not have the means to pay anything toward bond. He strongly denies the allegations, Your Honor. He is presumed innocent despite his history. He does not have the means to make any bond, as I stated earlier, and we heard that he is being held with $15,000 surety bond. He has no way of paying. This incident is alleged to have occurred back in July, and we are requesting a signature bond on Mr. Clark's behalf. And again, we are unopposed to any stay away conditions. Thank you, Your Honor.
All right, so it's going to be a $500 good bond on each of the charges, which makes it a $1,500 good bond. Stay away from the CVS and no drugs, alcohol, or weapons while out on bond. Ms. Gant, I would like you to follow up. If he is on, I'm going to give you the opportunity, Mr. Clark. Hold on for me for a second. I would like to see if you could follow up on the other misdemeanor charges that he has in Fulton County. And when he comes on my SAP calendar on December 6th, let's just make a note that possibly we can take care of all those at one time for him.
Yes, Your Honor. And Mr. Clark, I will give you a call at the jail to discuss your concerns. I don't want you to make any statements, so I don't want you to say anything to hurt your case. We've already discussed this.
Okay.
I would like to address the court, please.
Mr. Clark, I'm going to give you the opportunity. Put your hand down. Okay, go ahead. Put your hand down. Okay, Ms. Gant doesn't want you to speak, but you have a right. Okay, I understand. So I'm just going to make sure you understand. You have a right to remain silent. Anything you say can be used against you. You have solicitors on the line that are going to be taking down everything you say. So quite often people think that what they say is going to help them, and it doesn't. But if you want to address me, I'm going to give you that opportunity. So unmute courtroom 2.
How you doing today, Your Honor?
I'm doing fine,
First and foremost, I would like to address the court to say this. I served this country. I did 2 tours. I risked my life. I've given my life. I pay taxes. I do a lot for this country. Yes. Do I have mental illnesses that have me where I be in rapid mode, where I have a tendency to do things? I'm not going to speak pertaining to cases or cases I've been involved with. But what I will say is I have mental health issues. All right. I was just recently a victim of being stabbed. I was robbed. I was stabbed 4 times. I had a collapsed lung. I sat in Grady for I don't know how long. And again, that life experience, the traumatization I went through also brought me to the realization that I need to be here for my kids. Have I made mistakes in my life? Yes, I have. Do I ask for leniency? Absolutely, because we're only human. We're imperfect. We're going to make mistakes, Your Honor. I've made numerous mistakes, but if you notice, they all been along the same line of things. It's not like I'm just going out saying, oh, I'm gonna rob a bank today, and then I'm gonna go do this today. No, they're all within the same thing, which shows I have a history of something's not computing within my mental, where I'm just seeking mental help. That's what I really need, not jail time, not incarceration, because clearly what has that done?
This is what I'm
almost done. Oh, we're gonna, so what I'm saying is, Your Honor, listen, I just sit back in this courtroom and listen to numerous other cases. You got a child cruelty, but they're able to get a signature bond. I have yet to have one signature bond since I've been in the state of Georgia. Now, yes, all my crimes are, you can say obstruction and things of that nature, but those are all allegations until proven guilty. So I have yet to be presumed innocent, yet I have served this country. I gave my life for this
All
country.
right, Mr. Clark, the judge has ruled, and let us allow him to finish his statement, sir.
Yes.
And this is what I'm gonna, Mr. Clark, you're gonna see me back, and it's gonna be me. You're gonna see me back on the 6th. Ms. Gant, I would like a social worker to go down and speak with Mr. Clark. And at that time, I'd like, when he sees me again, for the social worker to report to me. So, Mr. Clark, I understand what you're saying, okay?
Yes, sir.
So
Yes, sir.
I'm gonna try to get you some help, and you're gonna see me the next time, and I'll remember you, okay?
Thank you, sir. That's
And
all
so-
I'm asking. Like, I need mental health, not these. I need.
Okay, so we'll see if we can try to get you some help, okay? So you're gonna see me, you're gonna see me back, all right?
Thank
And we'll have a discussion the next time you see me, okay?
Yes, sir. I can respect that. Thank you. And
All
enjoy
right.
holiday weekend.
You do the same. Thank you, Mr. Clark. Good luck to you, sir. We'll see you
All
back.
right.
All right, thank you, Your Honor.
You're welcome, Ms. Gant.
This is gonna be Denisha Clark on the add-on, position 1.
Good afternoon, Ms. Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? I'm sorry, Ms. Clark. I didn't hear you. Can you say that again?
Good afternoon, and no, I wouldn't like my video on.
Ms. Clark,
Yeah.
please remain silent. The judge has some statements to make to you.
Good afternoon, Ms. Clark. You have been charged in case 22 CR 007925G with simple battery family violence. Is there a history, Mr. Howard?
I got first arrest.
Okay. Ms. Campbell?
Yes, Your Honor, that is correct, that this defendant does not have any prior history. The facts as alleged are that on the date of November 21st, 2022, at the location of 2223 Lenox Road in Atlanta, Georgia, at approximately 2:01 p.m., officers did make contact with the victim in this matter, Ms. Sharikia Delisser, and that is spelled SHEREIKA. Her last name is DELISER. The victim did inform them that the defendant, it looks like, bit her. And it looks like the officer did not observe any marks, but the defendant did claim that she was told by the victim, who is her mother, to ask her for $50 from her brother. And then at that time, that's when the victim's mother bit her or struck her, bit and struck her. And upon speaking to a third-party witness, Cleon Clark, which is the defendant's brother, he stated that the mother grabbed the defendant's shoes from the floor. A tussle then ensued. And then, according to him, the defendant pushed the victim, and the victim grabbed a shoe off the floor, and then she was arrested as the primary aggressor. So for those reasons, with there being no history, the state's recommendation is a $3,000 signature bond through pretrial services, no further violent contact with the victim, Sharikia Delisser, as well as 1-day anger awareness, and no alcohol, drugs, or weapons while on bond. Nothing further from the state.
You object to any of that, Ms. Gant?
No, Your Honor. My client wants to continue having contact with her mother as well, and I did have the occasion to speak to Ms. Delisser, and she informed me of the same.
Yeah, I see Mr. Lizer on the line. Mr. Lizer, good afternoon. You are not required to speak, but if you would like to address the court this afternoon, this is your opportunity to do so. If you would like to, I'll need for you to unmute yourself, and I'll have to swear you in.
Okay, good afternoon, sir.
Good afternoon. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Lanisha is my daughter and I love her very much. I work so hard to help her and take care of her, and I just want her to be good and just listen what I have to say and just work with me as a mom and help me as a mom. I'm not telling her anything bad. You understand? So I'm not pressing any charges on her. And I just hope this is a lesson for her so she can understand and be a good girl. She's not a bad girl that have bad companies and stuff like that. No. I just want her to know that I'm a mother and I'm trying to help her and she know the situation. You understand? I just want her to be a good girl and become somebody better than I am.
You're not afraid of her back into your household? Is that correct?
I don't hear you.
You're not afraid of her and you would like to have contact with her?
Yes, I would like her to have contact with her and she's free to come back home.
Okay. Thank you, ma'am. I appreciate it.
You're welcome.
So it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with her mother, and no drugs, alcohol, or weapons while out on bond. I would also just like to encourage the solicitor's office that this looks like it might be an excellent case for the diversion program, if that's something that you all will consider in the future. Okay. Thank you, Ms. Delasser, and you also, Ms. Clark. Good luck to you, ma'am.
Thank you, Your Honor.
Position 16, Sharp.
Judge Morrow, if I may make an inquiry with courtroom 2.
Yes.
Courtroom 2, is Sergeant Norris there?
Yes, he is.
Okay, I just wanted to make sure we had sent the paperwork to the right individual. I appreciate it. Thank you.
You got it. You're welcome. This is going to be position 16, Mr. Sharp.
This is Taylor Sharp. Good afternoon, Mr. Sharp. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You have your case heard by video?
Yes, sir.
Thank you. Mr. Sharp, you've been charged in case 22 CR 007909G with simple battery family violence. Is there a history, Mr. Howard?
16 total between Georgia and Missouri. Last arrest was in August out of Missouri for domestic assault, first degree. It appears to be open. He was arrested here in March for out of Ackworth for battery DV. He had a May arrest for simple assault. That was not prosecuted out of Woodstock. What else? 2013 out of Tennessee. That was for suspended license. Let me see. I'm going to the Missouri history now. 2018 says stealing motor vehicle, unlawful use of a weapon. The weapon was dismissed by the court. 2013 possession of stolen property. 2009 theft, assault on law enforcement. I don't see a disposition for that. 08 robbery in the first degree. Unlawful use of a weapon in 2008. That was dismissed by the court. 05 passing bad checks, and 04 burglary, stealing. That's it.
Ms. Campbell?
Yes, Your Honor. For this defendant, the facts as alleged are that on the date of November 11th, 2022, the victim in this matter, Mr. Justin Stevens, was driving on 75 North when the defendant was seated in the passenger seat and punched him in his face with a closed fist. The victim reports that the defendant punched him so hard that he actually lost control of the vehicle and hit the shoulder. He struck a wall on the shoulder of the highway, the interstate, And the defendant and the victim are married. And so, like pretrial mentioned, there are two very recent arrests out of Cherokee County, also alleging battery, family violence, as well as simple assault. And so for those reasons, the state does believe that this defendant poses a risk of reoffending and that he's a danger to this victim. And so the state's recommendation for bond is $3,500 surety bond, no further contact at all with the victim, Justin Stevens, as well as a stay away from the victim's address. We don't have that in the police or in the warrant, but I'm also asking for a one-day anger awareness course.
Has your office spoken with Mr. Stevens?
We did attempt to make contact, but we were unsuccessful this morning.
Mr. Lynch?
Your Honor, Mr. Taylor is 36 years old. He does live in the Kennesaw area. Prior to that, he was living in the Woodstock area. He is working at this time. He's an information technology manager at Peak Technology out of Alpharetta. He also does home health care. I believe him and the alleged victim in this matter may have done some home health care work together. So that's another thing that he does in the community that we would put before Your Honor as far as ties to the community. We would ask, he also, another thing to bring to the court's attention is that as a result of the accident that happened in this case, he was hospitalized and he had an operation on his hip. And so that is something that he's having to deal with while in jail, which is one of the other reasons why we asked the court to consider a signature bond in this case. And if Your Honor were to determine that he's not eligible for a signature bond, we would ask that you set the bond a little bit more reasonable amount for him to be able to make in this case, perhaps in the area of $1,500 rather than the $3,500 requested by the state. I believe the alleged victim and my client are not residing together at this point. And so I don't believe that would be an issue as far as contact, as far as the residence is concerned. But that's what we're asking the court at this time, Your Honor.
All right, so it's going to be a $1,500 good bond. No further contact with Justin Stevens. Stay away from Mr. Stevens's residential address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Sharp.
Thank you, sir.
Position 11, Mason.
Good afternoon, Mr. Mason. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. We have a case heard by video.
How you doing?
I'm doing fine, sir. Do you agree to have your case heard by video?
Oh, yeah.
Okay, thank you. Mr. Mason, you've been charged in case 22 CR 007906D with improper erratic lane change, driving under the influence of alcohol less safe, driving under the influence of alcohol concentration is 0.08 grams or more, and possession of an open alcohol container. Is there a history, Mr. Howard?
This is fourth arrest. Yeah, 2005 out of Illinois, forgery, 2 counts of burglary. He was arrested in 2011 out of Maryland, assault 2nd degree conviction. Another 2011 arrest, assault 2nd degree conviction. That's it.
Kim, you're mute.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of November 21st, 2022 at approximately 11:30 p.m., officers were at the location of Georgia 9 and Georgia 140 in Roswell, which is near Holcomb Bridge Road. They did observe this defendant failing to maintain his lane. So they did conduct a traffic stop. At the time that they conducted the traffic stop, they approached the defendant and they immediately noticed the smell of alcohol emanating from his breath. They also noticed several clues indicating alcoholic impairment while they were observing him, including red and watery eyes, slurred speech, as well as they did the failed sobriety test, and they indicated that the clues indicated impairment. They also they had him take a breath test, and he did blow a 0.167, which is over twice the legal limit of 0.08. They also did conduct a search of the vehicle prior to taking him into custody for driving under the influence of alcohol. And they did find a partially full bottle of Crown Royal whiskey. It was open, and it was in the passenger compartment within reach of the defendant. So the state does have serious concerns about the safety of the community with regard to this defendant, considering the fact that he was driving around at well over twice the legal limits. And he was also not maintaining his lane, so he could have arguably hurt other motorists, but thankfully he did not. So for those reasons, the state is going to be recommending a $7,000 split bond, $3,000 surety bond on the DUI per se, $3,000 signature bond on the DUI less safe, $500 surety bond on the open container, and $500 surety bond on the failure to maintain lane. The state is also recommending no alcohol while on bond, as well as no driving while on bond.
Thank you, Ms. Kim.
Yes, Your Honor. Mr. Mason is, he was born in 1984, and he has been here in Georgia for about 11 years. He has 2 children, and one is in Puerto Rico, one he resides with. He also has, he's not married, but he has child of mother that he's also taking care of. So he is responsible for 3 family members, and he's the sole breadwinner. He has an employment. He's gainfully employed at Jorento Place. He sets up the events, and he does catering, and he builds tents. He's been doing that for the last 7 years. He graduated from high school. He also has some college education. However, he couldn't finish and get the degree. And yet, this is his first DUI case, Your Honor. And we don't want to argue the facts, and yet we do not know whether that machine breath test, whether it was calibrated correctly, whether it was conducted by the licensed or certified person. We do not know any of those facts at this point. So we would like to request that the bond is right now set up at $5,580. We don't want that to be increased from that. However, indeed, we do want it to be a little bit lower than that maximum, about $3,000 good bond. Thank you.
All right, so for the improper erratic lane change, a $250 good bond, the DUI less safe, $1,000 good bond, the DUI concentration of 0.08 or more, $1,000 good bond, and the open container, $250 good bond, makes for a total of a $2,500 good bond. No drugs, alcohol, weapons while out on bond.
Thanks.
Good luck.
Honor.
You're welcome. You're welcome.
Position 8, Harper.
Good afternoon, Mr. Harper. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Harper, you've been charged in case 22 CR 007919B with criminal trespass. Is there a history, Mr. Howard?
15 total. Last arrest was 2020. Possession of meth and possession of drug-related objects. I think it was dismissed. 2017 phase to appear not prosecuted. I got first offender for felony obstruction 2017. Obstruction misdemeanor possession of marijuana, no low from 2016. Suspended license 2012. Probation for suspended license 2011. 2010 probation leaving the scene of an accident. 2010 suspended license conviction. 2009, suspended license, NOLO. 07, probation for disorderly. 06, simple battery arrest.
Thank you, Mr. Howard. Ms. Backus?
Yes, Your Honor, and this incident occurred yesterday. An officer responded to the Premier Apartments at 1935 Allison Court Southwest. Upon arrival, the security guard, Miss Talitha Anderson, said that she found an unknown male sleeping inside one of the vacant units, and he was not supposed to be there. So she escorted him out of the apartment and to the leasing office to await police. And the officer spoke with the manager, who said that she wanted him formally trespassed from the location. There's already a $500 surety bond in place. The state is asking that remain in place. Stay away from that incident location, and no alcohol, drugs, or weapons while out on bond.
Does he have a place he can live, Ms. Gant?
Your Honor, he is residentially challenged. However, he has a mailing address, and he also has a sister who lives in the court's indulgence. Union City, Miss Janice Harper, his sister, she has a residence for him in Union City, Georgia.
All right, so it's gonna be $1,000 signature bond through the jail and no drugs, alcohol, or weapons while out of bond. Stay away from the incident location. So you can't go back to that location, okay, Mr. Harper? All right, good luck to you, sir.
Thank you, y'all.
You're welcome.
Position 17, Sterling.
Good afternoon, Mr. Sterling. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. We do have the case heard by video.
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 007910F with criminal trespass and battery felony violence. Is there a history, Mr. Howard?
42 total is what I have. Last was 2019 for stealing out of Missouri. Got history out of Missouri, Illinois, Alabama, and Ohio. Where to begin? Hold on. I'll go with Missouri first. So you have the 2018 endangering the welfare of a child, 2nd degree. 2017 shoplifting, assault 1st degree, burglary 1st degree. Those were dismissed. That was from 2012. Got a 2011 arrest out of Missouri, passing bad checks, theft less than 500. 2010 failure to return property. On to Illinois. Last arrest there was in 1996. So got a 2009 arrest by the feds. I guess it was federal probation. Got Ohio, 07 passing counterfeit money. Yeah. I'll leave it at that.
Hey, Ms. Campbell.
Yes, Your Honor. This is Mr. Jamison Sterling, correct?
Yes.
Okay. As to Mr. Sterling, this is a cross complaint. The other defendant is facing charges in Superior Court for this incident. So his charges are not before our court at all. So the facts as alleged for this defendant are that on the date of November 21st, which was yesterday, at the location of 250 Piedmont Avenue, apartment 2006, this defendant was in a verbal altercation with the victim, the other cross defendant in Superior Court, Enzion Wilkins, and that's Enzion, last name Wilkins. This defendant did destroy the property of the victim. He specifically destroyed his birth certificate and his state ID with a knife. This defendant also struck the victim allegedly in the face and the chest and knocked his phone out of his hand as the victim was trying to record the incident. And the officers did review the video and they did see this defendant striking Enzion Wilkins. And they did see the phone, going out of his hand as he was struck. And so the victim also reported that this defendant choked him and drug him out of the apartment. The apartment does belong to this defendant. And basically, this defendant told the police that he was trying to get Enzion Wilkins out of his home. And he stated that he had been allowing him to stay there because he was homeless. So as pretrial mentioned, this defendant is a multi-state offender. What I will note for the court is that most of the history, if not all of the history, is nonviolent and it is remote. This is only his second arrest in Georgia. However, in light of the allegations before the court today, the state does believe that the defendant is a danger to the victim. And so the state is recommending a $3,000 surety bond. And that can be broken down equally between both the charges, $1,500 on each charge. I believe, is there one charge or two? I believe there's.
Criminal trespass and battery family violence is what I have.
That's correct. So $1,500 on each count. And the state's also recommending no further contact at all with Enzion Wilkins and a one-day anger awareness course. Nothing further from the state.
Mr. Lynch.
Your Honor, my client's 50 years old. A little bit about him. He is an attorney, from my understanding, barred out of Wisconsin, but working in Georgia. With regards to his criminal history, I can't untangle all of it, but I believe at least some of those charges will be resolved without convictions based on some fraud, and I can't speak to that, but I believe at least some of the more recent charges may be resolved that way. He does have an identical twin, and that may play into that. I'm not sure. I can't speak to that, Your Honor. He does do a significant amount of pro bono work in the community. He does donate significantly to the Salvation Army every year. And the state mentioned that the cross defendant is not before this court. We understand that. My understanding, though, is that, well, first of all, this incident did happen at 250 Piedmont Avenue, which is an apartment on the 21st floor. My understanding is that the charges against the alleged victim are for destroying property, i.e. electronic items, by throwing them out the window of the 21st floor of that apartment building. My client contends that any contact he may have made was to prevent items from being thrown out the window of that apartment building, which of course is a danger to anyone below. Your Honor, we would ask that you consider setting a signature bond in this case. I do not believe there are any violent convictions on his record. And let's see. That's all that we would put on the record at this point.
Okay. Mr. Sterling, you have a right to remain silent. Anything you say can be used against you. I know that you understand that. I am going to give you a signature bond. I'm going to give you the opportunity to speak with Mr. Lynch at a later time. If you'd like to do that, I don't want you to incriminate yourself regarding any.
I would like to say something, Your Honor, simply because anything I say.
Mr. Sterling, I'm going to let you speak. Of course, I understand, but I just want to caution you that any comments on these allegations, you could inadvertently incriminate yourself. And until we have a conversation about that further, I would advise against making any comment on the factual nature of the allegations. But that being said, with that caveat, I'm not going to attempt to prevent you from speaking.
Your Honor, I'm conditionally admitted to the bar, and these allegations could cause that to go away. And so I would like to say that most of what whoever the person was, and I'm not sure, because most of those convictions, I have an identical twin brother that has a substantial drug history, and those convictions are his. Those have nothing to do with me. And so I wanted to at least set that straight on the record. All of those 42 convictions, that's not Jameson Sterling. That's my identical twin brother. We have the same date of birth and essentially the same social security number that's 2 digits apart. So that's all. Thank you, Your Honor. I understand I didn't have to speak, but that's not.
All right. So Mrs. Sterling, it's going to be $1,000 signature bond for the criminal trespass, a $3,000 signature bond for the battery family violence. So it's going to be a total of a $4,000 signature bond through the jail. No further contact with Mr. Wilkins and no drugs, alcohol, or weapons while out on bond. Okay, good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Position 6, Fleetwood.
Good afternoon, Mr. Fleetwood. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Fleetwood, you've been charged in case 22 CR 007917E with criminal trespass. Is there a history, Mr. Howard?
12 total. Last arrest was 2020. Battery DV. It just says merged out of Clayton County. 2018 probation out of Gwinnett. Yeah, the battery DV conviction. 2018 out of Clayton. Robbery and battery. 2016 out of College Park. He went to prison after that. On probation for ag assault, ag battery. Well, ag assault, I'm sorry. Well, both. They gave him 10 years probation in 2016 for that out of Gwinnett County. 2015 probation violation, felony theft by taking. 2013 probation, got obstruction conviction, carrying weapon without a valid license from 2011. Possession of tools, criminal attempt to commit a felony, and misdemeanor obstruction conviction 2012.
All right, thank you, Mr. Howard. Ms. Dacus?
Yes, Your Honor. This incident occurred July 21st of 2021. Officers responded to a dispute call at 678 Gillette Avenue. Upon arrival, the officer viewed another officer's body-worn camera footage, as well as spoke with the victim, Miss Markeisha Brown. It appears that the defendant and Miss Brown have children together. She said that he's the father of her twin boys and that they were arguing, and he punched the screen door and the glass shattered. She told officers at that time that she wanted him to stay away from her home and from her. Your Honor, the state's concern is really with the numerous violent offenses, the battery family violences, the ag assault, ag battery. And so because of that, the state is requesting a $2,500 surety bond, no further contact with Markeisha Brown, stay away from the incident location, 678 Gillette Avenue, and no alcohol, drugs, or weapons while out on bond. Nothing further.
Mr. Lynch?
Your Honor, this is my case, Mr. Fleetwood.
Ms. Gant. Ms. Gant, does Mr. Fleetwood have any reason to be at the Gillette Avenue address or around Ms. Brown at this time?
No, Your Honor, but we would ask for third-party transfer as they do share 2-year-old twins.
Okay, so it's going to be a $2,000 signature bond through the jail. No further contact with Ms. Brown. Stay away from the Gillette Avenue address. Third-party transfer for visitation of the minor children, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Gant?
Yes, Your Honor, thank you.
Okay, good luck to you, Mr. Fleetwood.
Thank you. Have a great holiday.
You do the same, sir.
Position 2, Blocker.
Good afternoon, Doctor. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Blocker, you've been charged in case 22 CR 007913G with criminal trespass. Is there a history, Mr. Howard?
Blocker 82 total.
Just give the last 5 or 6 years or so.
Last arrest was in April for driving without a valid license. They put him on probation for that out of Conyers. The rest of his history come out of Florida. Let me see. Got a 2017 arrest, petty theft. Got another theft arrest from 2017 out of Port St. Lucie. 2017, possession of drug-related objects. Dangerous drugs arrest. That was out of 2015. 2015, petty theft. 2013, petty theft. Another 2013, petty theft, shoplifting, possession of cocaine. That was from 2013 as well. It's a lot of theft.
Okay, thank you, Ms. Backus.
Yes, Your Honor, the incident, this incident occurred yesterday. Officers received a call regarding damage to a vehicle which occurred at 9995 Old Dogwood Road in Roswell. The caller, Mr. William Street, advised dispatch that someone stabbed his tires and that the suspect had returned to the scene, and there was video of the incident. Officers were given a description, and that individual was at the corner of Dogwood Road and Holcomb Bridge Road, walking towards the La Quinta. Upon approach, the officer identified the defendant and asked him what was going on, and he immediately said that he was in an altercation. He had some items in his hand, and so the officer had heard from dispatch he may still have a knife, and so he told him to drop everything, and he was searched for weapons. He continued to give officers a story about the altercation, but when asked about slashing the tires, he denied cutting any tires. Another officer returned to the Economy Hotel. They reviewed the footage, and it showed the male walking around the vehicle. He walked to the rear passenger tire, bent over. Then he's seen walking away, then returns to the vehicle, approaches the front side tire, bending over. And the officer noted that he could see like a motion of what appeared to be like a stabbing motion. The police report was fairly long, Your Honor, but essentially the defendant was seen on camera in position near the vehicle and making that stabbing motion on both the tires that were damaged. And he also matched the description and had the clothing of the same clothing as the individual in the video. And when asked about it by the manager, he did say that the shoes were his. The state is requesting a $1,500 surety bond, no further contact with William Street, stay away from the Economy Lodge at 9995 Old Dogwood Road. Nothing further.
Mr. Lynch.
Your Honor, my client is 60 years old. He does do some work laying tile, but he doesn't have an official employment at this time. He is currently homeless, although he does have a good mailing address that he's provided to me. Your Honor, it seems that at least in the last several years, he does not have an extensive record. And so he also certainly has limited means to make any bond. So Your Honor, we would ask you to consider a signature bond in this case. And if not, we would ask that you set the bond lower in an amount he may have a chance to make around either $500 or $1,000. But we would request a signature bond because in all likelihood, he's not going to be able to make bond on these charges. And so, any bond in that amount is tantamount to no bond. So, and we would just ask to consider that at least there's been a significant period with no serious arrests other than the traffic offense that was mentioned on his record.
Your Honor, I'm not exactly sure when this defendant was released, when he came to Georgia. The only thing that I saw in the GCIC, though, is that in 2017, there was a prison admission for grand theft. So the reason for him not committing any offenses may very well be that he was living in Florida and has recently come to Georgia. I'm not fully sure, Your Honor, but based on the fact that he is a multi-state offender, there is possibly a flight risk. The state would be requesting the surety bond. Nothing further.
All right, so it's going to be a $2,000 signature bond through the jail. Stay away from the Economy Lodge. No further contact with the alleged victim, and no drugs, alcohol, weapons while out on bond. Mr. Blocker, you can't go back to that Economy Lodge. You understand that?
Yes, sir.
All right. Good luck to you, sir.
Your Honor, can I make a request? This may be a bit unusual, but I would just ask that if possible, if one of the deputies could provide Mr. Blocker my contact number, because my understanding is his phone may be off, and I want to make sure he has the ability to get in touch with me as soon as he's released. Is that possible? I think the deputy should have my number.
Will do.
Okay,
Thank you so much.
Who do we have next?
Position 7, he's taking a plea.
Hey, I'm going.
So he's,
Your Honor, can we make sure that that Deputy Alton got my second email he sent over?
Ma'am, just address him by his last name, because we're,
Sorry, I think I had them switched. That's what I was trying to do. My apologies.
Okay, not a problem.
Okay. Just trying to make sure that he got the second email, because he sent the plea paperwork back, but there were some corrections that needed to be done.
Okay, I'll let him know.
Okay, thank you.
You're welcome.
And Your Honor, this client will be proceeding pro se, Your Honor.
all right. Mr. Fuchs, I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. I want you to know you have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney represent you in this matter. It's my understanding that although you've been provided with the services of the public defender, you would like to proceed pro se this afternoon. That's without the assistance of a lawyer. Is that right?
Yes.
Okay, and can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Fitch, you've been charged in case 22 CR 007918A with criminal trespass. Ms. Backus, what's the recommendation?
The state's offer was 12 months, serve 1 day. Credit for time served, 1 day, balance suspended, and stay away from the MARTA location at 2216 Peachtree Street Southwest in Atlanta.
Is that your understanding, Mr. Fuchs?
Yes.
Okay, and you would like to accept that offer from the state?
Yes.
So it's my understanding that in case 22 CR 007918A, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've had the opportunity to have a lawyer represent you. It's my understanding that you wish to waive assistance of counsel. Is that correct?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
You had the plea sentence sheet. Did you go through that sheet line by line and sign it at the bottom?
Yes.
You understand that if you're currently on probation, that your probation could be affected by this guilty plea?
Yes.
You understand that if you're not a United States citizen, your citizenship could be affected by, or your status could be affected by this plea?
Yes.
Do you give this plea freely and voluntarily, knowing what you've been accused of?
Yes.
Okay, I'll accept the plea, Mr. Fuchs. Good luck to you, sir.
Okay.
And again, Your Honor, it is Mr. Fuchs that needs to redo the paperwork.
Okay, so courtroom 2, if you'll have him do that, please. Who do we have next?
This is position 4. He's also taking a plea.
And again, Your Honor, I do apologize for interrupting. Mr. Dewberry will be proceeding pro se.
Good afternoon, Mr. Dewberry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yeah.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Mr. Dewberry, you've been charged in case 22 CR 007915E with criminal trespass. You have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present to represent you at these proceedings. We have provided you with the assistance of a public defender today. It's my understanding that you would like to proceed pro se and enter into a plea in regards to this criminal trespass charge. Is that correct?
Yes, sir.
Okay. Ms. Backus, what is the state's recommendation?
Your Honor, the state's recommendation is 12 months, serve 1 day, credit for time served 1 day, balance suspended. Stay away from Buddies at 1079 North Avenue Northeast in Atlanta. And we would ask that the defendant stipulate to the factual basis, venue, and ID.
So why don't you just go through it, Ms. Backus?
Oh, okay. The
I
factual
don't
basis.
know, I don't know if he's gonna
Understand, right, understood. Okay, that's fine. This incident occurred on yesterday. An officer was dispatched to Buddies at 1079 North Avenue. It's a convenience store. Upon arrival, the officer met with the reporting party, the store clerk, Mr. Al Masoom, who advised the defendant had previously been criminal trespassed from the property. And Mr. Masoom had asked the defendant to leave on this date multiple times, and he refused. He was throwing trash in front of the business and asking the patrons for money and cigarettes. Mr. Masoom did provide to the officer the criminal trespass warning from October 9th of 2020. Again, Your Honor, the state's recommendation was 12 months to serve, 1 day jail, credit for time served 1 day, balance suspended, stay away from Buddy's store at 1079 Avenue Northeast.
Is that what you want to accept, Mr. Dewberry?
Yes, sir.
All right, so it's my understanding that in case 22 CR 007915E, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been given the opportunity to have counsel in this matter. It's my understanding that you've waived your right to counsel and would like to proceed pro se, is that correct?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
And you received the plea sheet. Did you go through that sheet line by line and sign the bottom of it?
Yes, I did.
And do you understand that if you're currently on probation, that your probation can be affected by this guilty plea?
Yes, again.
And do you understand that if you're not a United States citizen, that your status could be affected by this guilty plea?
Yes, sir. Yes, again.
And do you give your plea freely and willingly, knowing the charge against you?
Yes, sir.
I'll accept your plea as negotiated, Mr. Dewberry. Good luck to you, sir.
All right, you have a good one.
All right, you too, sir.
I do have a quick announcement, Judge.
Okay.
For position 15, they waived their appearance.
Okay.
Do we have an announcement on position 5?
I was getting ready to say that.
Oh, I'm sorry. You said.
Okay. Position 5 is also, is gonna be a medical reset. And I'm still waiting for Officer Norris to come back in with the, so he can do the corrections once he gets his,
So,
And I have received that waiver.
all right, so medical reset for position 5 until tomorrow, 11/23. What about position number 13?
13. We're still trying to locate him, Judge.
Okay. So while we wait on that, why don't we go ahead and handle this waiver? And is this Ms. Kim's case?
Yes, Your Honor.
All right, so this is Shaman Pierce. Is there a history, Mr. Howard?
37 total. Last arrest was back in June for trespass and obstruction. Open trespass case out of the cab. Open shoplifting in Fulton. On probation for fare evasion, trespass, obstruction. 22 CR 004 005H. On probation for PI, that's 22 CR 003 290Y out of state court. On probation for felony obstruction, 19 SC 172946. Would you like more?
Okay, you're good. Ms. Campbell?
Did you say Ms. Campbell or Ms. Kim? I'm sorry, Your Honor.
Oh, yes, Ms. Campbell. I said Ms. Campbell. Is this your case?
Yes, Your Honor, this is my case.
Yes, go ahead.
Okay, so the facts as alleged for this defendant are that on the date of November 20th, 2022, at the 5 Point MARTA station, which is located at 30 Alabama Street, this defendant was observed sleeping on a platform there in the MARTA station. Officers did wake him up and ask him to leave the station. However, after being repeatedly asked to leave, he told the officers no. He specifically stated to them, "I'm not going nowhere. Y'all going to have to bring me to jail." So they did take him into custody since he refused to obey the lawful orders that they gave him to leave the station. As pretrial mentioned, this defendant is already on probation, several open probations here in state court. The two most concerning to the state as it pertains to this case are the most recent 2022 public indecency, which was also through MARTA PD, the arrest, and he was basically instructed to stay away from the Lindbergh MARTA station as a portion of his probation in that case. And then the other 2022 conviction here in state court for the fare evasion and the criminal trespass, this defendant was instructed to stay away from the Garnett MARTA station. So currently he's on probation. He's been instructed to stay away from two different MARTA stations. And here we have him at a third MARTA station, obviously not being compliant with the directives of the MARTA police. So the state is concerned about his risk of reoffending. He continues to participate in this type of behavior that, while it might seem innocent, is still unlawful and illegal. So the state does believe that a $500 surety bond is appropriate for this defendant. And at this point in time, since he's already been banned from two other MARTA stations, the state is going to be recommending that he be instructed to stay away from all MARTA stations at this time because he continues to break the law at the MARTA stations. Nothing further.
Ms. Kim, is he residentially challenged?
Actually, he says no, and he has a 275 PC Street as his address, Your Honor.
Okay. Go ahead.
Yes, Your Honor. He is 22 years old, and he's been here in Georgia for about 4 years. He came from South Carolina, and he's working at a waste department. It's a government. He's dumping the trash cans. That's his job. However, he only makes $400 a month, so he is qualified for public defender's service. He's been working there for about 3 years. He has the education up to 10th grade. Your Honor, we would like to request for a signature on bond for this case, and it is what it is. Thank you. He does not have any resources whatsoever in terms of finance.
All right, it's going to be $100 good bond. Abide by any MARTA suspensions and no drugs, alcohol, or weapons while out on bond.
Thank you.
Dude, how much you said it was?
100.
Okay.
All right, and it appears that we are waiting on position 13 and Mr. Lynch.
Yes, Your Honor.
We're gonna need to interview Mr. McShane.
That is correct, Your Honor. I haven't had a chance to speak to him yet.
Okay. So we're gonna give you that opportunity if they can find him. Let's go ahead and while we have some time, since we've taken care of everyone, Ms. Bridgewater, if we can go over the calendar while we're waiting.
Judge, might be excused for 5 minutes while y'all are doing that, and I'll come back to interview him. Would that cause any issues?
No, well, you're fine,
Thank
Mr. Okay.
Okay, once again, the reset date for the SAP calendar is December the 6th. Position 1 is reset to the SAP calendar with a $2,500 good bond. Position 2 is reset further notice with a $2,000 SOB through the jail. Position 3 is going to the SAP calendar with a $1,500 total good bond. Position 4 took a plea. Position 5 is being medically reset till tomorrow. Position 6 is reset further notice with a $2,000 SOB through the jail. Position 7 took a plea. Position 8 reset further notice with a $1,000 SOB through the jail. Position 9 is going to the SAP calendar with a $3,000 total good bond. Position 10 is reset further notice with a $5,000 total SOB through pretrial per judge. Position 11 is going to the SAP calendar with a $2,500 total good bond. Position 12 reset further notice with a $3,000 SOB through the jail. We'll hold it on 13. Position 14 reset further notice with a $3,000 SOB through pretrial. Position 15 is reset to the SAP calendar with a $100 good bond. Position 16 is going to the SAP calendar with a $1,500 good bond. Position 17 is reset further notice with a $4,000 SOB through the jail. Position 18 is reset further notice with a $3,000 total SOB through pretrial. And for the add-on, it is, hold on. I have it, hold on, I have so much paperwork on my desk. Give me a second. The add-on is reset further notice with a $3,000 SOB through pretrial. Are there any questions, comments, or otherwise?
Judge, you get that waiver?
Yes, I have, but I haven't had an opportunity to fill it out since I've been a little busy. Get it done for you, Mr.
Ms. Kim, I did receive your waiver.
Thank you.
You're welcome.
State, what happened with Tate, who was on the pool sheet? Did she bond out or something? Anybody know?
All right. Well, if there are no other questions, we'll be at recess until the jail comes back.
Your Honor,
Yes.
may
Ms.
I be
Kim.
excused?
Yes, have a good afternoon. Thank you.
Yes,
Thank
she
you,
must have
Honor.
gone. She's waiting for a pickup from another agency.
Say it again.
It was to the question I asked.
Your
Okay.
Honor,
Yes.
I don't know who's on the screen that will not be here tomorrow, but I would just like to wish everyone a happy Thanksgiving.
You also, Ms. Bridgewater. Okay, we'll be in recess until courtroom 2 comes back.
Okay.
And if you have, if you want to get me some of that paperwork, Ms. Bridgewater. I can
Oh,
go ahead.
I would love to. It's on its way.
Okay.
She's on one here.
Another case? Yeah.
Mr. Howard. Are you there? Is this Mr. McShane?
Come over here.
Yes, Your Honor, he has to talk to Mr. Lynch.
Okay, all right. So I just wanted to make sure.
Are we gonna do that in a breakout room or do I need to call someone?
We're gonna call you now, Mr. Lynch.
Okay, thank you.
All right.
Judge, excuse me, ready to proceed whenever the state is ready.
Okay. Good afternoon, Mr. McShawn. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. No problem.
Okay, thank you. You've been charged in case 22 CR 007907J with simple assault. Is there a history, Mr. Howard? Ms. Campbell, do you have the history?
Yes, Your Honor. So the history that I have for this defendant is that his most recent arrest was in 2021 for simple battery family violence. And it looks like he FTA'd back on January 13th of 2021 here in state court. He was actually given a signature bond through the jail in that case. And like I said, he did FTA and a bench warrant was issued and looked like the bench warrant. I didn't see that it was lifted or recalled or anything like that. So prior to that, he also had a 2020 arrest for criminal trespass and disorderly conduct. The facts as alleged for this defendant are that on the date of October the 4th of this year at the location of 2420 Piedmont Road, a MARTA police officer was flagged down by the bus operator, and her name is Alicia Matthews. Alicia is spelled ALICIA. She's the victim in this matter. She stated that she wanted a patron removed from her bus. Further investigation revealed that the patron was this defendant, Mr. Ernest McShan. The defendant boarded her bus with half of a fare card. And when the victim asked the defendant if she could see the picture on the back of his fare card, he refused to show it to her. And then he started using profanity towards her. The bus operator and the victim stated that she wanted him removed because of the profanity that he used. And the officers did review the CCTV footage from the bus, and they did see the defendant telling her he'll punch her with an expletive. And he also followed her, the bus operator, off the bus. So she got off the bus and he followed her, and he threatened to do violence to her person, essentially, and yelled profanities at her. And so the state does believe that this defendant, based on his prior history with the simple battery family violence, and also based on the fact that he FTA'd for that case, that he's a risk of reoffending, and he's a flight risk because he had a bench warrant in that case. So the state is recommending a $1,000 surety bond, a stay away from the MARTA station located at 2420 Piedmont Road. And the state is recommending that he be instructed to have no contact whatsoever with Alicia Matthews, the victim in this matter. Nothing further from the state.
Mr. Lynch?
Your Honor, we're not opposed to the stay away order from the alleged victim in the case. My client, Mr. McShan, is 62 years old, and he has lived in Atlanta, I believe in the Lindbergh area for the last 14 years. He is disabled. All his income would be disability income. He makes less than $900 a month. And so making a bond in this case will be a hardship for him. I understand the state's concern as far as the other charges, but I believe he hasn't not been convicted at this point of those charges which were mentioned. So we would ask Your Honor to consider a signature bond in this case. If Your Honor is not going to do that because of the FTA, we would ask that the bond be set no higher than $1,000 or even lower if Your Honor would consider it, just to give him a chance to make that bond. That's what we're requesting at this point, Your Honor.
All right, so it's going to be a $500 good bond. No further contact with Ms. Matthews. stay away from the Piedmont Road or Marta Station, and no drugs, alcohol, or weapons while out on bond. Okay? Good luck to you.
Understood.
Judge, how much was the bond, please? $500 good bond. Please, it was $500 good bond. Judge, was that a $500 good bond?
That's correct. All right, anything?
Ms.
further?
Bridgewater received.
Could I say something?
Raise your hand.
Mr. Lynch, your client has his hand up.
Mr. McShane, I would advise you not to make any statements about the factual nature of the allegations. It could all be used against you. The judge has set a $500 bond, which will have to be posted. But if you have another question, you know, I would advise about talking about the case in any manner, but you know, that is my caveat to you.
This is not really about the case. It's about, I stay in the neighborhood and I have to go through there just to get to the grocery store. So I will have to walk all the way around Piedmont. That's what I want to do. And see, the officers work off of Piedmont. So if I get stopped again.
Mr. McShane, I believe you're just going to have to avoid that MARTA station.
That's what I'm saying. Because see, I stay less than 3-4 blocks in front of my station. Matter of fact, I stay in front of the main headquarters.
Right. As far as my understanding is, as long as you don't enter the premises of that MARTA station, you're in compliance. So can you just stay off of the premises?
Yes.
Being close to it is not a violation, but entering onto the premises of that MARTA station would be a violation of your bond. Is that the court's order?
Yes. All right, good luck to you, sir.
All right, thank you.
You're welcome. All right. Happy Thanksgiving, everyone. Good to see you, Miss Crawford.
Thank you.
Good to see you too, Judge. Happy Thanksgiving.
Ms. Bridgewater,
Thank you, Judge.
did you receive my email?
I did, and I'm getting ready to send it over to the judge to sign. I have it. Thank you.
Okay, but it doesn't need to be resent and separated?
No, I have it all. You
Okay,
had two
perfect.
people, right?
Yes, as I said in the email, that the correct paperwork for Dewberry was sent connected to the errored paperwork from Fuchs. And so I
I
didn't
tell
know.
you what, let's do this here. Since it's late, resend it again.
Okay.
Yeah, I'll just get both of those so we won't go back and forth.
Okay.
So I can send it to the judge just to clarify it, okay?
Okay, sounds good.
Okay, thank you.
Thanks.
All right, y'all be good. Be safe.
Okay,
Thank you.
Judge.
Happy Thanksgiving.
Okay, same to you.